Now, we've all seen those movies where someone slaps a lawsuit on another person in a crowded restaurant. In the real world, things are a lot less dramatic, especially when it comes to serious matters like protective orders. Serving legal documents in these cases involves several specific steps to ensure that the respondent is properly notified and afforded due process. We're talking about protecting someone from potential harm, so it's got to be done by the book, folks. So, let's walk through the process step by step so you understand exactly how it works. First things first, the person seeking protection, we call them the petitioner, has to go to court and file a request for a protective order. This isn't just about showing up and saying, "I'm scared." They've got to fill out paperwork, specific forms required by the court, and provide evidence of the abuse or threats they've experienced. This could include photos, text messages, emails, voicemails, anything that supports their claim. The court needs to see proof, not just hear stories. Once they've filed, they'll get a date for a hearing. Now, depending on the situation, the judge might issue a temporary protective order or TPO right away. This offers immediate but temporary protection while they wait for the full hearing. Think of it as a stop sign to the abuser. The judge will set a hearing date to hear both sides of the story. This is where things get really important. That temporary protective order, along with the notice of the hearing, has to be delivered to the respondent, the person the order is against. And it can't be done by just anyone. It has to be someone authorized by law, like a sheriff's deputy or a process server, and they have to follow very specific rules. This isn't the mail, folks. You can't just stuff it in a mailbox and hope for the best. Once the respondent is served, the server has to fill out an affidavit of service. This is a sworn statement, signed under oath, confirming when, where, and how the documents were delivered to the respondent. That affidavit is then filed with the court as proof that the respondent was properly notified. This is crucial, because if the respondent doesn't show up in court claiming they didn't know about the hearing, well, we've got proof they're lying. Now it's time for both sides to present their case. The petitioner will explain why they need protection, and the respondent will have a chance to respond. And let me tell you, this is where things can get interesting. People can say all sorts of things to try and get their way, but a judge can spot a phony a mile away. After hearing all the evidence, the judge will decide whether to issue a permanent protective order. If the judge decides a permanent protective order is necessary, it's not just a piece of paper. It's enforceable by law. The respondent will be given specific rules to follow, like staying away from the petitioner or having no contact. Law enforcement is also notified so they're aware of the order and can act if it's violated. Violating a protective order is a serious offense and it can land you in jail. Look, serving legal documents properly, especially in protective order cases, is crucial to ensure that everyone involved is treated fairly. Remember, everyone deserves their day in court. That's why it's so important to follow the correct procedures. If you're ever unsure about any of this, don't just guess, folks. Consult with an attorney or seek legal advice from someone who knows the law in your jurisdiction. This isn't a TV show. This is real life with real consequences. Proper service of legal documents is crucial to ensure due process and the enforceability of protective orders. Always consult local laws or seek legal advice if needed. If you have any questions about serving a restraining order, please contact the Process Server Agency, LLC. 844-88-LEGAL, that's 844-885-3425 or ordertoappear.com.